The House will come to order. Today's Pledge of Allegiance will be led by Emmett Wood, Deck Ian Wood, and they're from Compass Montessori in Wheat Ridge, Colorado, and they're guests of Speaker Pro Tem Danielson.
For the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Representatives Arndt, Baker J, Baker K, Beckman, Benavides, Bridges, Bridges,
Excused.
Buck, Buckner, Carver, Catlin, Coleman, Covarrubias, Danielson, Escar, Escar,
Well, of course he does.
Excused.
Everett, Exum, Exum,
Excused.
Foot, Representative Foot, Garnett, Garnett,
Excused.
Janal, Gray, Hamner,
She is excused. Working on one of the best budgets I have seen in my entire time in the legislature.
Hanson, Harrod, Harrod,
Excused.
Putin, Humphrey, Jackson, Kennedy, Kraft Tharp, Landgraf, Lawrence, Lee, Leonard, Lewis, Liston, Lontine, Lundeen, McKean, McLaughlin, McLaughlin,
Excused.
Melton, Michelson Janae, excused, Neville, Pabon, Pedersen, Pedersen,
Excused.
Rankin,
Excused.
Ransom. Ryer. Roberts. Rosenthal. Zane. Salazar. Sandridge. Sias. Singer. Thurlow. Valdez. Van Winkle. Weissman. Willett. Williams. Wilson. Winter.
Excused.
Representative Exum is present. Wist. Young.
Who is it? Excused.
Madam Speaker.
So I've got Bridges. Bridges, Escar, Garnett, Hamner, Barrett, McLaughlin, Michelson, Janae, Pedersen, Rankin, Winter, and Young. I know I saw Escar was going to talk to him.
With 53 present and 11 excused and 1 vacant. We do have a quorum. Representative Hanson.
Thank you. Good morning, Madam Speaker. I move that the reading of the Journal of Thursday, March 22nd, 2018 be dispensed with and approved as corrected by the Chief Clerk.
All right, members, you have heard the motion. All those in favor signify by saying aye. Those opposed signify by saying no. Oh, that motion passes. Representative Rankin is present. Further, any announcements or introductions this morning? Now, I know there has to be some announcements and introductions. For anybody who is listening, does anybody have any announcements or introductions? Representative Landgraf.
Thank you, Madam Speaker. I was trying to get down here, but people were blocking my way. Members, the Veterans Caucus is going to be postponed due to the budget. We're going to be so busy, we didn't want to have people show up and not be able to participate ourselves. So we will be on track the following month, and it will be mental health and veterans courts.
All right, further announcements or introductions? Representative Coleman.
Thank you, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you, too.
I know everybody's busy doing something right now, but I got something really important to say. First of all, how y'all doing? That's right. I just want to acknowledge that we all represent great people here in Colorado, but you know, some of us are really blessed, like myself, to represent powerful, intelligent, awesome people like the rest of y'all, but especially in Colorado's House District 7. So I just wanted to acknowledge and have them stand and be recognized, the constituents of House District 7 today on HD7 Day at the Capitol. Thank you for being here.
Welcome to the Capitol. You have a wonderful representative. And that will be $1. Further announcements or introductions? Representative Ransom and Representative Singer.
let you start.
Okay. Good morning, colleagues. We would like to invite everyone to the Children's Caucus Lunch on Monday upstairs in SCR 357. You just show up. It's a wonderful lunch. We will be hearing 2 short presentations. The first one is from the Aurora Mental Health Center, dealing with trauma, and how it will affect kids in schools. Should be very interesting.
And what a great way to end a Friday than talking about poverty and child welfare. And so we won't end our Friday with that, but on Monday, we'll be getting some free lunch and having a good discussion on where do we go from here to help keep kids out of our foster care system with panelist Carrie Miller from the UC Denver. We look forward to seeing you all up in the Senate Committee Room 357, noon to 1 o'clock with our Children's Caucus.
Further announcements and introductions. Representative Melton.
Thank you, Madam Speaker, and I have a tribute.
Oh, great. Members, can we please have your attention? We're listening to a tribute this morning.
Thank you, Madam Speaker, and if the tribute can be read aloud.
The House of Representatives convened in the 71st General Assembly hereby extends sincere commendations to students against violence in schools. The victims of Stoneman Douglas High School were the most recent victims among the 496 victims of mass shootings in the past 10 years. 17 teachers and students lost the opportunity to ever laugh, live, and love again. Students have stated that they are committed to engage other students in their schools who might be alone and hurting, and we are proud to see students leading decisively in this country. The members of the Colorado House of Representatives are equally committed to listening to and following the lead of our students who are demonstrating tremendous courage. On request of Representative Jovan Melton, given this 23rd day of March, State Capitol in Denver.
Representative Melton.
Thank you, Madam Speaker. Members, you can be seated. We are preparing for a march that'll be conducted tomorrow by students all over the country and here in Colorado who really do want to make their voices heard and known that they want to stand up for school safety and against school violence. Unfortunately, Colorado is not one that has been immune to school violence with shootings at Columbine and then the Arapahoe High School situation, as well as other venues like the Aurora Theater shooting, which is very close to my own district. But I was encouraged to see last week so many students step out of their classrooms and come down here to the Capitol and march and say that, you know, we want to see our schools be safe and we want our voices to be heard. We want our legislators to hear what it is that they care about and that concerns them and this generation. In my generation, the most you ever had to really worry about was maybe a kid bringing a bat to school or something. But you know, for these students now to have to face having SROs and having metal detectors and things like that tells me that we live in a completely different world. And I don't consider myself to be that old, even though I did just have a birthday. But it's important to listen to the students who are actually going to school every day, having to face these challenges every day. And so as they prepare for their march tomorrow, I hope that we all just commend them for making their voices heard and for the courage that they have demonstrated over these past few weeks as all of this has been transpiring. Thank you.
Further discussion on the tribute. Thank you for joining us today. Further announcements or introductions? Representative Wilson.
Thank you, Madam Chair. Representative Coleman, I almost totally agreed with your announcement this morning as the other James brother here, as the exceptional people that we represent, but there's an exceptional person here from my district, which I'd have to say is most exceptional to me. My wife, Christy, is back in the chamber today. So those of you that have known her from before, please welcome her back to the chamber.
Representative Pabon.
Thank you, Madam Speaker Pro Tem. And we also have a guest of honor here from a little bit outside my district, actually outside the state of Colorado, and all the way in another state called California. We have the esteemed Ali Medina, who is the Vice Mayor of Emeryville, home of Pixar Studios and many others. So let's give Vice Mayor Medina a warm round of applause. Thanks for visiting us.
Representative Salazar.
Thank you very much, Madam Speaker Pro Tem. Just a reminder, noon today, grand entry March powwow, and it will last all the way up until Sunday, and hopefully some of you will want to go over there and partake in the spectacle. I was talking to Representative Covarrubias yesterday about it, and it's a blast. I mean, it is so much fun. So hopefully you'll all, come on up, man. It's all good. Some bipartisan solidarity for the American Indian community. And I mean, it's an amazing, amazing sight. There's definitely a spirit in the building that you can feel.
Representative Covarrubias.
Thank you, Madam Speaker Pro Tem. Honored to serve with you. I guess I take my kids to the powwow every year since they were really little, and it is just an awesome sight because of the headdresses and the gear that they wear, and when they're dancing and twirling down and up. The spectacle that it is just unbelievable. And one of the neatest things, if you do go down there, they will allow you to go down on the floor and go dance with them. And you can take your kids down and you dance and you do the steps, and it's just one of the funnest things. It's $10, $12 to get in, and it's just really a blast. I encourage to visit the powwow myself.
Representative Salazar.
Madam Speaker, it seems like Representative Covarrubias is about ready to get down and start doing some fancy dancing. Maybe we
do it. Let's do it together.
No, maybe not. All right. So hopefully we see you there. Thank you.
Representative Melton.
Thank you, Madam Speaker. And I'm sorry, I'm suffering from a little bit of a cold. I forgot to announce that we did have guests here, students who are leading the march tomorrow for students who want to stand up for school safety. So if you will help me welcome those student leaders that'll be leading the march tomorrow. Thank you.
Thank you for your leadership. Representative Salazar.
Sorry, people are like, okay, where's it at? It's the Denver Coliseum. Denver Coliseum all weekend long. What's that?
Representative Melton.
Thank you, Mr. Chair. So, Madam Chair, so since we just keep forgetting stuff on our own announcements, we should just stand up here all day and continue to add stuff in our own
Exactly.
Oh, many announcements and introductions this morning. Any further announcements or introductions? Seeing no further announcements or introductions, that takes us to third reading of bills, final passage. Mr. Randall, please read the title of House Bill 1155.
House Bill 1155, Representative Singer and Listen, House Member Tunes Minute, continuation of physical therapy board in conjunction with implementing the recommendations contained in the 2017 census report by the Department of Regulatory Agencies.
Madam Majority Leader Becker.
Thank you, Madam Speaker. I move for the passage of House Bill 1155 on third reading and final passage.
The question before us is passage of House Bill 1155 on third reading and final passage. There is discussion. Representative Liston.
Thank you, Madam Speaker. Members, I just want you to know that I know sometimes I can get under your skin with some of the needling that I do, and so this is your chance to really stick it to me, okay?
Oh, goodness. That'll be $1 fine. Mr. Randall, please open the machine, and members, please proceed to vote. Please close the machine. With 48 yes votes, 13 no votes, 3 excused, and 1 vacant, House Bill 1155 is passed. Co-sponsors.
No, but he's a co-sponsor. Marilyn Bone has to take his name off as a co-sponsor. We close the machine and then he removes himself, right? So, yeah.
Further co-sponsors? Please close the machine. Representative Pabon?
Thank you, Madam Speaker. And this is one of those awkward moments where I need to have my name removed as a co-sponsor to House Bill 1155. As I said yesterday, I support the concepts, but given the pending litigation, I had to vote no on the bill, and so I'm going to remove my name as a co-sponsor.
Representative Pabon's name will be removed. Madam Majority Leader Becker.
Thank you, Madam Speaker. I move to lay over House Bill 1262 till the end of the third reading calendar.
All right, seeing no objection, House Bill 1262 will be laid over until the end of the third reading calendar. Mr. Randall, please read the title of House Bill 1186.
House Bill 1186, Representatives Wilson and Ryer, Senator Marble, concerning continuation of the Colorado Youth Advisory Council in connection with the implementing of the sunset review recommendations of the Department of Regulatory Agencies, making an appropriation.
Madam Majority Leader Becker.
Thank you, Madam Speaker. I move for the passage of House Bill 1186 on third reading and final passage.
The question before us is the passage of House Bill 1186 on third reading and final passage. Mr. Randall, please open the machine, and members, please proceed to vote. Please close the machine. With 52 yes votes, 10 no votes, 2 excused, and 1 vacant, House Bill 1186 is passed. Co-sponsors. Please close the machine. Mr. Randall, please read the title of House Bill 1175.
House Bill 1175, Representatives Kraft, Harp, and Thurlow, Senator Gardner, concerning continuation of the House Law Regulation Committee Association Managers by the Director of the Division of Real Estate in connection with the implementing recommendations contained in the 2017 census report by the Department of Regulatory Agencies.
Madam Majority Leader Becker.
Thank you, Madam Speaker. That was impressive. Thank you, Mr. Randall. I move for the passage of House Bill 1175 on third reading and final passage.
The question before us is passage of House Bill 1175 on third reading and final passage. Mr. Randall, please open the machine, and members, please proceed to vote. Representative Melton. Please close the machine. With 38 yes votes, 24 no votes, 2 excused, and 1 vacant, House Bill 1175 is passed. Co-sponsors. Co-sponsors. Please close the machine. Mr. Randall, please read the title of House Bill 1235.
House Bill 1235 by Representatives Hanson and McKeon, House Senator Scott, concerning continuation of regulation of custom meat processor in connection with implementing recommendations 2017 Census report by the Department of Regulatory Agencies.
Madam Majority Leader Becker.
Thank you, Madam Speaker. I move for the passage of House Bill 1235 on third reading and final passage.
Question before us is the passage of House Bill 1235 on third reading and final passage. Mr. Randall, please open the machine, and members, please proceed to vote. Please close the machine. With 61 yes votes, 1 no vote, 2 excused, and 1 vacant, House Bill 1235 is passed. Co-sponsors. Please close the machine. All right, that takes us to general order. Oh. Yes, the one that was laid over. Mr. Randall, please read the title of House Bill 1262.
House Bill 1262 by Representatives Jackson and Roberts, House Senator Kagan, concerning the Arbitration Services Provider Transparency Act.
Madam Majority Leader Becker.
Thank you, Madam Speaker. I move for the passage of House Bill 1262 on third reading and final passage.
All right, Assistant Minority Leader West.
Thank you, Madam Speaker. I'm not sure what those groans were for.
Everything just got really serious.
Well, rightfully so. We're talking, members, about the importance of arbitration to our business community. And I apologize, I didn't come down in seconds yesterday. I was off the floor in a meeting when this bill came up. This received a very thorough discussion in our Judiciary Committee meeting, or hearing last week. So I wanted to share some of my thoughts with you about the dangerous trend that I see us going down. I'm not quite sure when arbitration became a dirty word. When did we start to think that the ability of our citizens to resolve disputes out of court in an inexpensive and expedient way was something that was not advancing the policy interests of our state? The central premise of this bill, and one that you'll hear at some point, is that consumers have no idea if an arbitrator could be biased, and little recourse should that be the case. Now, as you all know, arbitration is a well-developed and evolved form of dispute resolution with no shortage of oversight. And as a commercial litigator with 29 years of experience, I can tell you that I have arbitrated many cases successfully. Won some, lost some, but it's been an effective means of resolving disputes. What House Bill 1262 will do is add more layers of unnecessary regulation that will permit parties to grind down arbitrations in court. Members, it's very important that you understand the result of passing this legislation today, and that is that it will result in more cases going to court. Now, I think we all know that there are people outside this chamber that that's exactly what they want to happen. They want more and more disputes to be in court. They want more and more disputes to become class actions because that drives up fees for attorneys. And I will be the first to admit that the ones that always win in litigation are attorneys. They always come out on top. So let's talk about what House Bill 1262 will do. It will require extensive disclosures, and I think the issue here is, should parties be able to make a knowing decision regarding whether or not arbitrators have a conflict of interest? Absolutely. Arbitrators should be fair. Arbitrators should be impartial. Colorado law already does this. Colorado law already requires disclosure of partial or potential partiality. No party wants to spend the money to go through an arbitration process only to have that award vacated. So I'd encourage you to look at the Colorado Uniform Arbitration Act at 212, 1A and B. And that disclosure requirement, this is existing law, says the following. Before accepting an appointment, an individual who is requested to serve as an arbitrator, after making a reasonable inquiry, shall disclose to all parties to the agreement to arbitrate an arbitration proceeding and to any other arbitrators any known facts that a reasonable person would consider likely to affect the impartiality of the arbitrator in the arbitration proceeding, including the following things are enumerated, and I'd suggest you look at the provisions of this bill and compare what Colorado law already requires that an arbitrator disclose. A financial or personal interest in the outcome of the arbitration proceeding. B, a current or previous relationship with any of the parties to the agreement to arbitrate or the arbitration proceeding, their counsel or representatives, a witness, or another arbitrator. Again, already an existing law. Arbitration institutions already have an incentive to provide a fair and neutral forum. Most every arbitral institution provides heightened standards, rules, or guidelines to govern the partiality of their arbitrators. These standards are often more stringent than those for judges, and you can find those, and these are applied to arbitrations happening in our state today. The Code of Ethics for Arbitrators, Arbitrators' Ethics Guidelines, and IBA Guidelines on Conflicts of Interest in International Arbitration. Members, the following groups oppose this bill: the American Council of Engineering Companies of Colorado, the Associated Builders and Contractors, the Associated General Contractors of Colorado, Building Jobs for Colorado, Colorado Association of Commerce and Industry, CASI, the Colorado Association of Home Builders, the Colorado Association of Mechanical and Plumbing Contractors, the Colorado Bankers Association, Colorado Builds, the Colorado Cable Telecommunications Association, the Colorado Civil Justice League, the Colorado Competitive Council, Colorado Concern, COPIC, the Denver Metro Chamber of Commerce, NIAP Colorado, the National Federation of Independent Business, Mountain West Credit Union Association, Pinnacle Assurance, Premier Employer Services, and South Metro Denver Chamber. There is broad opposition to this bill in our business community. And why is that? Because arbitration has been an effectively used tool for many decades and hopefully for many decades to come. Now, we heard in committee concerns about overly broad arbitration provisions that you might find in some contracts that designate a specific arbitrator and require that Colorado citizens arbitrate in another state. If that is the concern, let's bring that bill. But let's not perform surgery with a chainsaw, because that's exactly what this bill does. I urge a no vote.
Representative Jackson.
Thank you, Madam Speaker, and thank you, Minority Leader Wist. Very much appreciate your comments and certainly agree that arbitration should be a fair and impartial proceeding. And that's why we're asking for the same kind of transparency that a person who has a dispute with a company, a service, or an employer would have in a court of law. And members, this bill is not about getting rid of arbitration. Let me make that clear. This bill is not about getting rid of arbitration. And in fact, Minority Leader Wist, as you had said you were not here for second reading, you may or may not be aware that there was an amendment offered, which was voted on and approved, which would offer up an opportunity, if both parties agree, to waive some of the disclosures that we are asking for. And let me also tell you about those disclosures. We're not asking for any more information than is already provided for in cases of arbitration in 4 other states. California's been doing that for 15 years. The same disclosures. And the sky has not fallen as it relates to arbitration. So members, this is about fairness. This is about transparency. I can give you lots of numbers about how many arbitration cases there are, how many arbitration contracts there are. Pretty much every contract you sign has a forced arbitration clause. So again, members, I ask that you think about those folks who may not have an opportunity to be made whole, and this bill would give them that opportunity. And I ask for your aye vote. And as far as groups supporting this particular piece of legislation, I have a page full. I ask for an aye vote. Thank you.
Further discussion? Representative Salazar.
Thank you, Madam Speaker. I too have been through a number of arbitrations throughout my career. Oddly enough, I never lost and I never won, because we were able to resolve things through the arbitration, which is a benefit. But I like this bill, and I'll tell you why. And it really concerns me when I hear that there's broad support or broad opposition to this bill, but it really isn't. It's very narrow. It's all about business interests. Because when I file a case in court and a judge is assigned to me, guess what I get to see? All those cases that that judge has presided over, the parties, the type of case, the amount of judgment, and I get to see if there's repetition over and over and over again with that particular judge, which there usually isn't. We have lots of federal district judges and lots of state district judges, but there's transparency in that. Our court system, our legal system, our judicial system doesn't allow for one party or another to try to hide any kind of information from the public. And it's just really odd to me, and it's kind of disconcerting, that business interests are opposed to transparency. And it's only business interests. You want to talk about broad support, is what Representative Jackson has in her hand, and I hope that you read that broad support. I think it's important for people to understand what broad support really means. What's wrong with transparency? We like to talk about it here. in this chamber. We support open records policies. We support all sorts of things. Over the numerous years that I've been here, we have championed transparency, except here. This bill just outlines what you would typically see or what you could review when cases are filed in court. Is it a province of corporations arbitration? Because if that's the case, then we should be worried. And no, this isn't about standing up here on behalf of corporations. This is about standing up here on behalf of corporations and people and employees, many of whom live in your districts. That's what this bill represents. It represents all of our constituents, from business constituents to our individual constituents. It represents transparency. Why would we not want that here? Why? Because business tells us that they don't want it? We are not here just for them. We're here for all those employees who signed these agreements. And when they sign the agreements, they should know what kind of arbitrator they get. We did an arbitration outside the Navajo Nation a few years back. That arbitrator, I was able to find out information about. And that arbitrator was typically the arbitrator who did work for the industry that we were going against. And we were really quite concerned about whether that person would act unbiasedly. And he did. We were able to get to a good resolution. But I really had to dig in to try to find that information for my client. And why is my client worth less than a corporation? Have we actually asked that question? Why are our individual constituents worth less than the corporate constituents? This bill doesn't shift the playing field in such a way that it takes away from an advantage from corporations. It levels playing field. And we like to use that word down here a lot too, leveling the playing field. I rise in strong support of House Bill 18-1262 because if people are going to go through a litigious process such as arbitration, they should be able to get pretty much the same kind of information that they would have to go, or that they would get if they had to go through federal court or state district court systems. Once again, I rise in support of House Bill 1262.
Representative Stain.
Thank you, Madam Speaker. Members, this is a broad bill about arbitration. And there's arbitration clauses written into many contracts. So for those of you who have told me over this session and other sessions that you don't want to get in the middle of a private contract, this is the bill to vote no on. And I'll just keep it short. This bill is also a surreptitious effort to undermine the work we did last year on attainable housing. The end, vote no.
Further discussion? Any further discussion? Seeing no further discussion, Assistant Minority Leader West.
Thank you, Madam Speaker. Let's put a little finer point on the point that Representative Sane just made. We spent a lot of time working in this chamber last year on bipartisan construction defects reform, and the Colorado Supreme Court affirmed in the Velazio decision the right of parties to arbitrate. This legislation is specifically intended to undermine that decision of the Colorado Supreme Court. Finally, with respect to the transparency that is sought in this bill, this is not a new issue. The Uniform Law Commission has uniform legislation that's been adopted in Colorado, the Colorado Uniform Arbitration Act, that's worked very, very well for a long time. If there needs to be a revisit of the uniform law on transparency and disclosures, I suggest we look to what the Uniform Law Commission has done, and may do. If there are revisions that need to be made to disclosure requirements, let's allow that process to play out. But to specifically undermine the Colorado Uniform Arbitration Act and its specific disclosure requirements, I would suggest would be a path we should not go down. So I'd encourage you, before you vote on this bill, to take a look at the pages and pages and pages of disclosures, new disclosures, that this law will require that arbitration services providers make. Now, if you're the American Arbitration Association, or JAMS, or a large arbitration service provider that's operating in California, yeah, you probably are doing some of these things. But if you're a small arbitration services provider, and we have many in our state who provide this service to business and provide expedient, efficient ways to resolve disputes, I would suggest that you're going to force a lot of them out of business. Maybe they'll do mediations, but they're going to be out of the arbitration business, because when you saddle them with the detailed page after page after page of disclosure requirements that this bill will do, I'd suggest that the effect of that will be fewer arbitration services providers in business, and that is exactly the intent of this legislation.
Assistant Minority Leader West, I did just want to let you know that your time is now up.
Vote no on this bill.
Further discussion, Representative Roberts.
Thank you, Madam Speaker. Members, thank you for the comments from all the members. What we just heard, though, is a parade of hypotheticals and what-ifs and sky is falling scenarios. But what we didn't hear is any facts. This law, this exact same law, has been in place in other states, in some states, for 15 years. And if it were true that this had an effect on affordable housing, or if it puts small arbitration service providers out of business, wouldn't we have had those facts? Those facts did not come out in the Judiciary Committee hearing. They have not come out on the floor. It is all hypothetical. This bill does not end arbitration. It does not get rid of that practice. It does not get into anybody's contract for arbitration and to undergo an arbitration proceeding. This bill is about letting consumers who are forced into arbitration know a little bit about what they are about to get into, just like anybody, any one of us could go look up the history of a judge that we are just about to appear in front of. This is about fairness to consumers, not about ending arbitration. In fact, it is about acknowledging that arbitration is a part of our lives and will continue to be more a part of our lives, but let's let the consumers have a little bit of fairness, and let's acknowledge that the scenarios we just heard have no factual basis behind them. I'd urge an aye vote.
Representative Carver.
Thank you, Madam Speaker. The most compelling testimony for me against this bill in committee was from the Colorado Bar Association. Their section, mediation section, but it covers arbitration and mediation, came in and gave very strong, extensive testimony against this bill. And they talked about an array of challenges that this bill would pose and be very, very disruptive to arbitration in Colorado, issues that this bill raised that needed to be worked. And I verified that even with the amendment that was done on seconds, that CBA is still opposed to this bill because of how disruptive it would be to arbitration. And a final point, there was a reference by Representative Roberts that this bill is operating in other states, including California. But it's just been brought to my attention that even in California, they don't have the upfront challenge process that is included in 1262. So in that respect, we're going even further than the California law Again, this has not been worked out with those that actually do arbitration. CBA is strongly opposed to this bill, and I would urge a no vote.
Minority Leader Neville.
Thank you, Madam Speaker. Members, I've been talking a lot about how when we pass laws, it contributes to the rising cost of living in Colorado. And I think this bill is exactly what I'm referencing when I talk about that. We've heard that California has this. Well, folks, do we really want to look towards California to solve the affordable housing problems we have in this state? I don't think they've solved it in their own state. And it's exactly because of bills similar to this. This will result into more litigation, which will result into higher cost of living on numerous products, not just housing, but numerous products across the state. I urge a strong no vote.
Representative Weissman.
Thank you, Madam Speaker. Members, to the point about process and the views of the Bar Association received drafts of this legislation, I think, over a month ago, and were invited to submit comment. And those involved with this legislation have spoken with them. Concerning disclosure, it is a correct statement of the Uniform Arbitration Act, 1322, Part 2, which, by the way, was last updated 14 years ago. Many, many, many evolutions in the practice of arbitration in the actual world ago. There are some disclosures in there which are made in the context of an individual arbitration. There is nothing in there concerning disclosures made by what the bill calls an arbitration service provider, the entity that oversees many individual arbiters. I think my colleague from Adams County ably stated the need for those kinds of disclosures. When you go before a judge, it's possible to see other opinions. By that judge, there are strict anti-conflict of interest standards in the Code of Judicial Conduct for judges. I also want to make abundantly clear that there is nothing about this legislation that will cause an arbitration to cease and give people the right to go litigate the underlying matter in court. This bill does not do that. This bill cannot do that. That is the impact of the Federal Arbitration Act, which we and all other states are subject to. Again, this bill is not going to let people go to court who are subject to an arbitration clause. This bill is only going to put parameters on the practice of that arbitration. You can have whatever view you would like of that reality, but that is simply the reality. And finally, why is it appropriate to have a little bit of disclosure about arbitration service providers? Some of you have heard me put it this way. I'll put it this way again. An arbiter is somebody who stands in the shoes of a judge. A judge is somebody who applies the law to your set of facts and thereby determines your rights. That is why Article 3 of the United States Constitution and Article 6 of the Colorado Constitution set up an independent judiciary as one of the three legs of our tripartite stool of government. I would go further and suggest that an arbiter also stands in the shoes of the jury, because an arbiter determines what the facts are, as well as applying the law to those facts. And again, this bill is not going to change who goes before a judge and who goes before an arbiter. That is the power of clauses in contract. That is the power of the Federal Arbitration Act as interpreted and applied by the United States Supreme Court. All the bill proposes is a little bit of transparency for arbitration service providers. I don't think that's too much to ask, and I think a yes vote is appropriate.
Seeing no further discussion, Mr. Randall, please open the machine, and members, please proceed to vote.
Representative Humphrey? Please close the machine. With 34 yes votes, 28 no votes, 2 excused, and 1 vacant, House Bill 1262 is passed. Co-sponsors. Please close the machine. All right, that takes us to the end of the third reading calendar. Next up is general orders, second reading of bills. Representative Hansen. All right, members, you have heard the motion. Seeing no objection, Representative Hansen will take the chair.
So much. Oh, I'm good. I've got mine marked up. The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for a reading of a bill at length. Committee amendments will not be read unless requested, as they are printed in your bill folders. Floor amendments will be shown on the screen and not read unless requested. Bills will be laid over upon the motion of the majority leader, and the coat rule is relaxed. Mr. Randall, please read the title of House Bill 1149.
House Bill 1149 by Representative Kennedy, Senator Neville, concerning continuation of the Consumer Insurance Council.
Representative Kennedy.
Thank you, Mr. Chair. I move House Bill 1149 in the Appropriations Committee report.
Thank you. To the committee report.
Thank you, Mr. Chair. In the Appropriations Committee, they added an appropriations clause. The grand total of this is $1,200 per year to fund reimbursements for the rural members of the council. I ask for an aye vote.
Representative Kennedy, one moment.
Is there not?
No. I think we are in a position to go straight to the bill. All right, let's go straight to the bill. Representative Kennedy.
Thank you, Mr. Chair. I am sorry. There was an appropriation, but somehow it didn't require an amendment in the Appropriations Committee. So the bill itself, this is a continuation of the Consumer Insurance Council. It's a group of volunteers who like to hang out over at the Division of Insurance and communicate two ways back and forth between the division and the consumer groups out there to make sure we're holding our Division of Insurance accountable. I think it's a great program that is worth continuing. And I would also like to move Amendment L2 and ask that it be properly displayed.
I don't have it.
Jacob has it.
I know, but I need.
Oh.
Members, you have heard the motion. L002 has been moved and is now properly displayed. Representative Kennedy to the amendment.
Thank you, Mr. Chair. One thing that we forgot to do when we were initially drafting this bill is make sure it comes up for a sunset review again. We think that that is a prudent thing to do, and make sure we take a look at this council again in 10 more years. So I ask for an aye vote on the amendment.
Seeing no discussion, the question before us is the adoption of L002. Pardon me, Representative Wilson.
Thank you, Mr. Chair. And thank you, Representative Kennedy, for bringing this amendment. Colleagues, if you looked at the bill, it did say indefinitely, which is a phrase I do not like. on any commission, bill, or otherwise. We spent a lot of time this morning in thirds voting on sunsets. The only reason why we come up with a debate on those issues is because it does have a sunset. So consequently, we talked about it in this bill that this is going to go on forever. I've got a few concerns about the committee itself. When we get to the bill, I'll talk about that, but this addresses partially, because it's 10 years, none of us will be here, so none of us will have any information on how this has worked and how things have worked in the past. I would have recommended a 5-year sunset on it, so at least some of you would be here. I would not be here, but at least some of you would have been here to have had that conversation. But that being said, I appreciate the fact that we do now have a sunset, so this committee doesn't go on forever without being checked out. So thank you.
Any further discussion on the amendment? Seeing no further discussion, the question before us is the adoption of L002. All those in favor, please say aye. Aye. Those opposed, no. L002 is adopted. Now back to the bill. Any further discussion on the bill? Are you going to go first? Representative Ransom.
Thank you, Mr. Chair. As Representative Wilson mentioned, we did discuss this council extensively in committee. And the one thing I just want to say for those of you that are familiar with the sunset review process and that we get reports with recommendations, the department actually recommended that we discontinue this council. Their recommendation was it's no longer needed, it's not effective, it's not doing what it's supposed to do, and they recommended that we do an actual sunset. And to that end, I actually think that we should listen to them, that we should recognize that while insurance can be an issue, and I do appreciate the sponsor adding on another sunset, I still feel that in this instance we should pay attention to the department's recommendations that this council is ineffective, it's not doing what it's supposed to do, and it's no longer needed. I urge a no vote on the bill.
Any further discussion? Representative Wilson.
Thank you, Mr. Chair. Colleagues, the concern that I had in terms of the committee, if I were to stand here and tell you that I'm the 5th Congressional District Representative for the Consumer Insurance Council, you'd probably be more impressed than if I told you I was Representative Wilson. You know, it's a nice title, but what does it actually do? And here's my concern, and Representative Kennedy, you might be able to speak to this, but the letter of support that actually came from the council had this statement in it. We have recently worked to clarify our advisory role and now list specific recommendations to the division in our meeting minutes. How long had this been going on? 9 years. But we have recently decided that we would clarify our advisory role. I rest my case on maybe wanting to review this again rather quickly, because if we just recently decided what we were going to do, then it's obviously not an earth-shaking contribution to the insurance process here that we're getting from the commission. So if you could speak to that, Representative Kennedy, I'd appreciate it.
Representative Kennedy.
Thank you, Mr. Chair. I certainly can speak to it. I think that reading the review from DORA about why they did not want to continue this program, they had some understandable concerns. One of the things that was in the existing statute was that the commission, it said may, not shall, the commission may issue an award to an insurance carrier who they thought was doing a great job. The council did review that requirement. They opted not to because they didn't actually feel it was very appropriate for a consumer advocacy group to be giving out an award like that. So that was actually one of the criticisms of DORA on why they didn't want to continue the program. And we actually, as part of this bill, we're actually removing that section from statute, taking out the whole conversation about an award. To Representative Wilson's point, one of the other criticisms was that this council had not issued formal recommendations to the Division of Insurance or to the insurance commissioner. And first of all, the statute didn't actually direct them to do that. The previous statute did not direct them to issue formal recommendations. So what they had been doing was giving informal recommendations, when they faced the criticism that they received from DORA about the continuation of the program, that was when what they did was clarify their mission. So they're still basically doing the same thing, but they were calling it something different. Instead of the informal recommendations that had previously been offered, they were just putting specific, clear directives on what they thought the Division of Insurance should be doing in their meeting minutes officially. So I think that clarification is a constructive step for them to be taking, but the mission is the same as it had been over the years before.
Representative Beckman.
Thank you, Mr. Chair. I stand in objection and ask for a no vote on House Bill 1149. If you look at the bill itself, it takes out all mission, directive, goals, and objectives for this commission. We heard testimony from this commission that has never been fully appointed, that they like to sit around and discuss issues. Actually, the sponsor of the bill says they like to hang out at the insurance division, and that's kind of what they do. The department requested that this be sunsetted and that this go away because it was not functioning based on the legislation that was currently written. What we've done to the legislation is we've gutted out all of it. So we now have a commission that has no directive at all. I would really ask you to look at 1149. We took out their directives because they didn't like that, but we haven't added anything in to replace what is the role, besides political, besides just making comment and having a title, what is the role? What benefit do we want to get out of this Consumer Protection Committee? Because right now there is none. I compare it to the Stroke Advisory Board that is based out of the CDPHE that also has a very low fiscal note. In fact, it doesn't have any. They have very specific directives that state database, public access, treatment and prevention. These were dictated within the legislation. That is how an advisory board should be creative. This board that has no fiscal note is always fully appointed board. This board has a mission. It has goals. It has objectives dedicated in the legislation. So what this committee has done for years is said, well, we don't want to do what the legislation says. We don't want to do that. And we've taken the legislation and taken it all out. So now we have an advisory board that has no direction. It has no goals or objections. We haven't set a course. Maybe next year we could step back and really define what we would like this committee to do. But for right now, as the sponsor said, I don't think we should appoint a committee to hang out at the insurance division. I ask for a no vote.
Seeing no further Representative Ransom.
Thank you, Mr. Chair. I just want to bring up one more thing. If you'll all take out your bill and look at it, most of what is in the 1.5 pages of language is crossed out. There's only a few lines left that actually say anything about this council. And again, when we were encouraged to actually let it sunset, we looked at the language, and I recognize that we've added a sunset in the amendment that was just passed, but please take a quick peek at the bill, look and see how that there's only a few lines left even in the bill. And while some people say, oh, this is a very simple bill, and they want to say that that is a good reason for passing it, I'm going to say that that's a good reason for not passing it. And the very last section 4, then I know that you've heard me talk about safety clauses before, but with a very short bill that only has a few lines in it, then they end saying that this act is necessary for the immediate preservation of public peace, health, and safety. So it's immediate. We're being told that this is an emergency, that we have to get this done with a safety clause. And so even that provision alone, it just shows that I think that this council is something that we're maybe looking at tradition and not good policy. And finally, I just would like to renew my motion, remove my urging of a no vote on this bill. I just think that this is one of the councils that we don't need to have in our government right now. Thank you.
Seeing no further discussion, the question before us is the adoption of House Bill 1149. All those in favor, please say aye. Aye. Those opposed, no. No. The ayes have it. 1149 is adopted. Mr. Randall, please read the title of House Bill 1234.
House Bill 1234 by Representative Baker Kane Lundin, House Senator Gardner, concerning clarification of laws governing simulated gambling activity.
Representative Becker.
Thank you, Mr. Chair. I move House Bill 1234 and the Finance Committee report.
Madam Majority Leader, I have down Business Affairs and Labor.
Oh, I'm sorry. Gosh, I think that was 3 years ago when I ran this bill and it went to Finance. It actually did go to business.
All right, to the committee report. Representative Lundin.
Thank you, Mr. Chair. I move Amendment L003 to the committee report and ask that it be properly displayed.
Thank you. Members, you have heard the motion on L003. It has been properly displayed. Representative Lundin.
Thank you very much. In the committee, the Business Committee, the able eyes of the committee members picked up on a question. What does per occasion mean? This amendment answers very clearly what per occasion means. That is the purpose of the amendment. I urge your support.
Thank you. Any further discussion on the amendment? Representative Van Winkle.
Thank you, Mr. Chairman. This is an amendment that I felt was very necessary in committee when it came up, and I very much thank the bill sponsors for thoughtfully pursuing it and thinking the issue through. Thank you.
Wonderful. Seeing no further discussion on L003, the question before us is the adoption of L003. All those in favor, please say aye.
Aye.
All those opposed, no. L003 is adopted. Madam Majority Leader.
To the committee report. In the Business Committee, we adopted a strike below that includes definitions for gambling and prize to deal with the situation of illegal gambling arcades. I ask for an aye vote.
Seeing no further discussion, the question before us is the adoption of the Business Affairs and Labor report. All those in favor, please say aye.
Aye.
Those opposed, no. The committee report is adopted. Now back to the bill. Representative Lundin.
Thank you very much. This is a good bill. It follows on the work that the General Assembly has been doing, defining what gambling is and where we want to have it in the state of Colorado. I urge your support.
Madam Majority Leader.
Thank you, Mr. Chair. And I also ask for an aye vote. We are trying to deal with illegal gambling arcades that have proliferated in Colorado in the last couple of years. These are arcades that run slot machines that look like, sound like, act like, serve like slot machines. And our Colorado Constitution is clear that those slot machines are only, that gambling is only supposed to take place in 3 places in Colorado. Attorney General John Suthers has previously said that these activities are illegal, and we're just clarifying it in statute that they are in fact illegal. I ask for an aye vote.
Seeing no further discussion, the question before us is the adoption of House Bill 1234. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it. Bill 1234 is adopted. Mr. Randall, please read the title of House Bill 1250.
House Bill 1250 by Representative Kraft, Arbor, and Sias, House Senator Pioli, concerning analysis and review of compliance with departmental rules by regulated businesses.
Representative Kraft-Tharp.
Thank you. So I move the Business Affairs and Labor Committee report and House Bill 1250.
Wonderful. To the committee report. She did.
I just said, and House Bill 1250. Yeah. So let me say it clearer. I move House Bill 1250.
Thank you. That is a proper motion. To the committee report, Representative Kraft-Tharp.
Thank you. So Business Committee and Business Affairs and Committee report. So we had 2 amendments on here. Do you want to talk about it?
It's okay. Go ahead.
Okay. So one is one of the factors to for analysis of the rules to be added is the enforcement level and any appropriate fines for non-compliance with the department rules. So that was one amendment. The second is to clarify that this bill is not asking for the departments to do anything new, but it is asking for a compilation of the fines that they are setting on businesses that are not in compliance with rules. So with that, we could ask for support of the committee report.
Thank you. Any further discussion? Seeing none, the question before us is the adoption of the committee report from Business Affairs and Labor. All those in favor, please say aye.
Aye.
Those opposed, no. The committee report is passed. Representative Sias to the bill.
Thank you, Mr. Chair. This bill requires each state agency to conduct an analysis of its noncompliance with the rules to identify rules with the greatest frequency of noncompliance, and particularly taking note of where fines have been assessed, to whom, for what reasons, and for how much. I will let my co-sponsor elaborate if she deems it necessary, but it is a good bill. Came through business, I believe, with 12-1, and I would request an aye vote.
Thank you. Representative Kraft-Tharp.
Thank you. So this section may be familiar to you all. This section was in House Bill 1250 last year, and this is not regulatory reform, but this is who are we fining, what are we fining the businesses for, what rules are being violated. So let's take a look at what's happening in our departments. We ask for your support.
Thank you. Seeing no further discussion on the bill, our question before us is the passage of House Bill 1250. All those in favor, please say aye.
Aye.
Those opposed, no. The bill is adopted. Mr. Randall, please read the title of House Bill 1065.
House Bill 1065 by Representatives Beckman and Buckner, also Senator Lambert, concerning discipline in the Department of Human Service employee who the employee is found to have mistreated a vulnerable person.
Thank you so much, Representative Beckman. Representative Buckner.
Thank you, Mr. Chair. I move House Bill 1065 and the Judiciary Committee report.
Thank you. To the committee report. Representative Beckman.
Thank you, Mr. Chair. The committee amended the bill to better define mistreatment, abuse, neglect, exploitation for our institutes in the state, Colorado Department of Human Services facilities, to ensure that we were not infringing on employees' due process and employees' rights.
Representative Buckner? All right. Seeing no further discussion, all those in favor of adopting the Judiciary Committee report, please say aye.
Aye.
Those opposed, no. The committee report is adopted. Representative Buckner, to the bill.
Thank you. To the bill. This bill directs the Department of Human Services to prioritize the safety of vulnerable persons when it considers taking disciplinary action against an employee. It also allows the department to move more easily to suspend or dismiss an employee that is found to have mistreated a person in his or her care. I am asking for an aye vote on this bill.
Thank you. Representative Beckman.
Thank you, Mr. Chair. This bill passed out of Judiciary unanimously after 2 meetings. It's been a long journey for Representative Buckner and myself, and I do want to thank the Judiciary Committee for helping bring this bill along to bring the equal balance of protecting employees' rights and also protecting those most vulnerable in our institutes, which are the mental health institutes, youth service centers, veterans community living centers, the regional centers, and we care for about 7,000 individual clients a year in those every day in those facilities. We have caring and amazing employees that provide professional care to residents, but there are some who don't and should be disciplined. And this bill is going to make it very, very much easier for good managers and good employees to do that. So I would ask for an aye vote.
Thank you. Seeing no further discussion, the question before us is the passage of House Bill 1065. All those in favor, please say aye.
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 Those opposed, no. House Bill 1065 is adopted. Mr. Randall, please read the title of House Bill 1109.
House Bill 1109 by Representative Weissman, Senator Cook, concerning discretionary parole of special needs offenders.
Thank you. Representative Weissman.
Thank you, Mr. Chair. I move 1109 and the Judiciary Committee report.
Thank you. To the committee report.
Members, the committee report clarifies the process by which a competency determination is made for a special needs offender under the bill. If any, the process is that the court will appoint somebody qualified to do a competency determination, and the custody of the individual remains with the Department of Corrections.
Representative Weissman.
Thank you, Mr. Chair. For the interest of further clarity on the committee report, I move 005 to the committee report.
Members, you have heard the motion. L005 has been properly moved and displayed. Representative Weissman, to the amendment.
Thank you, Mr. Chair. This amendment is just to clarify the intent of the committee report. I bring it at the request of DHS. There is no objection to other stakeholders, including OSPD and DOC. I ask for your support on the amendment to the committee report.
Seeing no further discussion, the question before us is adoption of L005. All those in favor, please say aye.
Aye.
Those opposed, no. L005 is adopted. Representative Weissman.
Thank you. I urge support of the committee report as amended.
Seeing no further discussion, the question before us is the adoption of the Judiciary Committee report as amended. All those in favor, please say aye.
Aye.
Those opposed, no. The Judiciary Committee report is adopted. Representative Weissman.
Thank you, members. 1109 is a bill concerning compassionate release parole. It will impact only a few tens of inmates per year. This is a mechanism by which those who are very old and very ill can be put to the parole board for discretionary, not even mandatory, but discretionary release. This is about making more effective use of our limited criminal justice resources and DOC beds without compromising public safety. The bill was 10-0 out of committee, and I ask for your support.
Seeing no further discussion, the question before us is the adoption of House Bill 1109. All those in favor, please say aye.
Aye.
Those opposed, no. 1109 is adopted. Mr. Randall, if you would please read the title of House Bill 1211.
House Bill 1211, Representatives Wist and Foote, House Senator Smallwood and Aguilar, concerning controlling Medicaid fraud.
Representative Foote.
Thank you, Mr. Chair. I move House Bill 1211 and the Judiciary Committee report.
Thank you. To the committee report, Representative Foote.
Thank you, Mr. Chair. Members, we made a number of amendments during the Judiciary Committee as a result of quite a bit of stakeholder outreach and feedback. We made, I believe, a total of 6 amendments to the Judiciary Committee report to amend some definitions into the bill, to deal with the mental state of some of the crimes that would be part of this bill, and also dealing with the jurisdictional issue between the district attorneys and the attorney general. And so we made a number of those amendments. I think those amendments really helped us bring everybody on board in on this particular bill. Having said that, we do have one other small amendment to the committee report that we'll be moving here in just a second, that will just clean up some of the language that we made in one of the amendments during the committee. Again, it's more of a cleanup language that we'll speak about in just a minute. But having said that, I move L009 to the Judiciary Committee report.
Thank you, members. You have heard the motion. L009 has now been properly displayed. Representative Foote, to the amendment.
All right. Thank you very much, Mr. Chair. L009 amends the mental state in one of the particular offenses here in this Medicaid fraud bill, and it really just changes it around in the paragraph. So the mens rea, the mental state, is included in the middle of the paragraph in one of the amendments that we put in committee. This is just going to put the specific intent mental state at the beginning of the paragraph, just to make it clear that the specific intent is what controls the behavior that's part of this particular paragraph of the offense. So we ask for an aye vote.
Seeing no further discussion on L009, the question before us is the adoption of L009. All those in favor, please say aye.
Aye.
Those opposed, no. L009 is adopted. Representative Foote, to the committee report.
Thank you, Mr. Chair. There are no further amendments we're offering on the committee report at this time, so we ask for an aye vote on the committee report.
Seeing no further discussion, the question before us is the adoption of the Judiciary Committee report. All those in favor, please say aye.
Aye. Aye.
Those opposed, no. Ayes have it. The committee report is adopted.
Do the amendment on the bill first.
Representative Foote, to the bill.
All right. Thank you, Mr. Chair. Members, we'll do a quick introduction to this bill in just a second, but just to get it out of the way, I wanted to move an amendment that is a technical amendment to the bill, so I move L008 to the bill.
Members, you have heard the motion. L008 has now been properly displayed. Representative Foote, to the amendment.
Thank you, Mr. Chair. This takes out the appropriations clause. It was initially included because there was the thought that there may need to be an appropriation, but that, of course, did not happen. We got a fiscal note back for no appropriation, so we are therefore taking out the appropriations clause. Ask for an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of L008. All those in favor, please say aye.
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 Those opposed, no. Ayes have it. L008 is adopted. Representative Wist to the bill.
Thank you, Mr. Chair. Members, our state receives nearly $4 billion in federal Medicaid funding, and part of the condition for receipt of that Medicaid funding is for Colorado to have a Medicaid fraud control unit in order to regulate the disbursement of that money and to protect vulnerable Coloradans from neglect and abuse. Now, our Medicaid fraud control unit has been operating since the Romer administration under an executive order. However, due to recent court challenges to challenge the specific authority of the Attorney General's office to have this unit, we think it's very important for us to clarify the intent, our intent, that this unit continue to operate as it's required to do under federal law. You should also know that this unit's been operating very successfully for many years, recovering millions of dollars of fraudulent Medicaid requests from providers. So this in no way is intended to change anything other than to codify existing practice. Appreciate the very detailed and broad stakeholder process that we went through on this bill and ask for your support.
Representative Foote.
Thank you, Mr. Chair, and I don't have too much to add to that. This is a bill that really attempts to get rid of the tenuous relationship that exists right now between an executive order and prosecuting cases. We're just codifying what has been done since 1978, but just making sure it's in statute. And as the Assistant Minority Leader noted, there has been extensive stakeholder feedback that resulted in a number of amendments. It appears that everybody's on board, or at least neutral on this bill. And FSL, we ask for an aye vote. Thank you.
Thank you. Seeing no further discussion, the question before us is the adoption of House Bill 1211. All those in favor, please say aye.
Aye.
Those opposed, no. House Bill 1211 is adopted. Mr. Randall, please read the title of House Bill 1243.
Yeah, should we switch?
House Bill 1243, Representatives Foote and Wist, House Senators Corman and Fields, concerning enactment of a civil rape shield law.
Go ahead.
Oh, so confusing. You've switched spots. I don't know what to do. Who would like to start? Representative Wist.
Thank you, Mr. Chair. Well, since the last one was a Wist-Foote bill and this is a Foote-Wist bill, we thought we would change sides here at the podium. But in all seriousness, members, well, I guess I should move the bill first. I move House Bill 1243. There is no committee report.
Thank you. Representative Wist to the bill.
Thank you, Mr. Chair. Members, for many years under Colorado's criminal code, we've had a rape shield law that has protected victims from their past sexual histories being introduced into evidence at a criminal trial involving sexual assault. What this does is takes that same principle and applies it in the civil context. So in cases involving sexual harassment, sexual misconduct, sexual assault, civil sexual assault, this makes clear that if the parties intend to litigate and introduce evidence of those issues, that they're required 63 days before trial for there to be a hearing in camera, for that evidence to be presented to the judge, and then the court would make a determination before this information would get in front of a jury. Rule 403 of the Rules of Evidence state that it's our duty when we're balancing probative evidence and evidence that's unduly prejudicial, that we'll make sure that we effectively carry out that balance, and the civil rape shield law that's before you would help the court do exactly that. So I think it's an important piece of legislation, one that's been overdue and needed for a long time, and happy to bring it before you and ask for your support.
Representative Foote.
Thank you, Mr. Chair. And just to add on to what has already been said, this is a very important bill. It's going to help protect survivors of sexual assault that go the civil route for what happened to them. It's been done in several other states, I believe 17 states, and also in the federal system. So this isn't something that's new. It's just something that we haven't had in the state of Colorado. And the committee hearing actually on this bill was quite powerful. There was one person that came in that spoke about her experience after having filed a civil suit after what happened to her. And as someone who is a practitioner in the criminal area, I was stunned and taken aback about some of the questions that she had to answer during the course of her deposition in this civil case. They would have been not even considered relevant and not even considered to be asked in the criminal realm. Yet they were asked time and time and time again in this deposition, and they were just, quite frankly, out of line, ridiculous, and that's the kind of thing this bill will help prevent in depositions, also in civil trials, just like it does in the criminal world very effectively. So we ask for an aye vote on this bill.
Thank you. Seeing no further discussion on House Bill 1243, the question before us is the adoption of House Bill 1243. All those in favor, please say aye.
Aye. Aye.
Those opposed, no. Ayes have it. House Bill 1243 is adopted. Mr. Randall, please read the title of Senate Bill 107.
Senate Bill 107 by Senator Zenzinger, also Representative Thurlow, concerning the repeal of procedures to fill vacancies, candidate nominations for elections conducted under the Colorado Municipal Code of 1965.
Thank you. Representative Thurlow.
Thank you, Mr. Chair. I move Senate Bill 107, and there is no committee report.
Thank you. To the bill, Representative Thurlow.
Thank you, Mr. Chair. 107 is a statutory revision committee bill. It is brought to us by the Municipal Clerks Association. The problem they're trying to address, the Municipal Code of 1965 defines a vacancy committee procedure for nonpartisan offices like City Council. So if a candidate decides to resign as a candidate after he started the process and turned in his petition, but before the election, there's a vacancy committee process, just like we have in partisan elections. But of course, in a nonpartisan election where somebody is petitioned on, the concept of a vacancy committee doesn't make any sense. The other little oddity in the current law, it defines if there's no vacancy committee named in the petition, the vacancy committee is defined as the first three people that signed the petition. So that could be the first three people that you found walking through the shopping mall and got them to sign your petition. So it's just one of the anachronisms in law that the clerks brought to us, and 107 does away with that anachronism. I ask for an aye vote.
Seeing no further discussion, the question before us is the adoption of Senate Bill 107. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it. Senate Bill 107 is adopted. Mr. Randall, please read the title of House Bill 1275.
House Bill 1275, President Bridges, Officer Senator Kagan, concerning the repeal of the Craig Hospital license plate donation requirement.
Thank you. Representative Bridges.
Thank you, Mr. Chair. I move House Bill 1275. There is no committee report.
Thank you. To the bill.
The bill is for Craig Hospital. They currently have a $20 donation requirement to get a license plate. They would like to waive that donation requirement. They have an awesome new logo, and they want that logo out there on as many cars as possible.
Thank you. Any further discussion on House Bill 1275? Seeing none, the question before us is the adoption of 1275. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. House Bill 1275 is adopted. Thank you. Mr. Randall, if you would please read the title of House Bill 1261.
House Bill 1261 by Representative Weissman, concerning the Colorado Arbitration Fairness Act.
Madam Majority Leader.
Sorry. Thank you, Mr. Chair. I move to proceed out of order for the immediate consideration of House Bill 1282.
Members, you have heard the motion. Without objection, we will proceed to consider Senate. Sorry, did you say?
House Bill 1282.
Thank you very much. All right. You've heard the motion. Without objection, we will proceed out of order to House Bill 1282. Mr. Randall, please read the title of House Bill 1282.
House Bill 1282, Representatives Lentini and Sias, also for small wood policy requirement that a health care provider include certain identifying information on all claims for reimbursement for health care services.
Thank you. Representative Lontine.
Thank you, Mr. Chair. I move House Bill 1282. There is no committee report.
Thank you. To the bill, Representative Lontine.
Thank you, Mr. Chair. For being late, I will have Representative Sias tell you about it.
That seems only fair. Representative Sias.
Very nicely deflected. What this bill does, and I will mention this came out of Health Insurance and Environment by a vote of 12-1, I believe. It simply seeks to require that all hospital-owned but off-campus facilities, in other words, an office or a freestanding emergency room, use its own what's called an NPI or a facility code, a national provider identifier, when they submit their bills, so we have the geographic location of where services were actually performed. Happy to elaborate if we have any discussion down here, but I would encourage an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of 1282. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. 1282 is adopted. Mr. Randall, please read the title of House Bill 1261.
House Bill 1261, Representative Weisman, concerning the Colorado Arbitration Fairness Act.
Mr. Weisman, Representative Weisman, excuse me.
Thank you, Mr. Chair. I move 1261 on the Judiciary Committee report.
Thank you. To the committee report.
Thank you. The committee report makes a couple of mostly cleanup changes. It adds a definition of client to clarify who is or is not a client of an arbitration services provider or an arbiter. Also adds a detail that certain agreements should be in writing. I ask for your support.
Representative Carver.
We are to the committee report.
All right. The question before us is the adoption of the Judiciary Committee report on House Bill 1261. All those in favor, please say aye.
Aye.
Those opposed, no. The Judiciary Committee report is adopted. Representative Weisman.
Thank you, Mr. Chair. I move L9 to the bill.
Members, you have heard the motion on L009. It has been properly moved and now properly displayed. Representative Weisman to the amendment.
Thank you. Members, L9 provides with abundant clarity that provisions of Title 13 in our judicial code concerning award of fees against a party who proceeds without merit, and also provisions of Rule 11 of civil procedure apply in these matters. Arbitration is to be taken seriously, and certainly no attorney who is part of an arbitration should attempt to invoke relief without substantial basis. So I'm happy to make this clarifying amendment, and I ask for your support.
Thank you, Representative Weisman. We'll give just a moment for folks to read the amendment, see if there's any further discussion. Representative Wist.
Thank you, Mr. Chair. And I guess my question about the amendment is, how does this relate to the award of attorney's fees elsewhere in Colorado statute?
Thank you, Representative Weisman.
Thank you. As best I can answer, there is no attempt to change the award of attorney fees outside of the proposed 1322 Part 7. This just makes clear that Rule 11 and the Section 102 provisions for award of fees against a party who proceeds frivolously or without merit are applicable here. This is to address concerns that the mechanism set forth in this bill might be used unduly, and this is to attempt to address those concerns. I ask for your support.
Representative Wist.
Thank you, Mr. Chair. So my related question is, how does this affect a contractual provision that is essentially a loser pays or an attorney's fees provision that exists under contract?
Representative Weisman.
There is no intent here to impact provision of a contract. Without getting into too much detail, I believe there are certain provisions, generally speaking, in CRS that allow a contract to depart from otherwise prevailing fee provisions or that work in conjunction with contractual fee provisions, e.g. in 13-40, which is outside the four corners of this bill. Again, this is just to try to make very clear that to proceed non-meritoriously under the proposed 1322 Part 7 is to subject oneself to fees if the court agrees that an attempt to invoke injunctive relief was without merit.
Representative Wist.
Thank you, Mr. Chair. Representative Weissman, thank you for the explanation. My final question relates to Section 3 of L009. I think it's unnecessary. Rule 11 applies to all motions. I don't know why we'd have to say in statute that Rule 11 would apply to a motion for injunctive relief.
Representative Weissman.
I agree that these provisions are generally applicable. The intent here is to address concerns that have been raised by various parties about the provisions we are setting forth in 1261. This is just to make it abundantly clear.
Seeing no further discussion, the question before us is the adoption of L009. All those in favor, please say aye. Aye. Those opposed, no. Ayes have it. L009 is adopted. Representative Weissman to the bill.
Thank you, Mr. Chair. I move L15 to the bill.
Members, you have heard the motion on L015. That has been properly moved and now properly displayed. Representative Weissman.
Thank you, Mr. Chair. This amendment does two things. I'll start from the bottom. There was a similar amendment, if it fits on the screen there. There was a similar amendment run yesterday on 1262. This is just to clarify that if both parties agree post-dispute and in writing that the provisions of this bill may be waived, this is to take cognizance of the fact that arbitrations are different, and sometimes it is an entirely appropriate mechanism as between parties who agree, so this is just to clarify that. The top part of the amendment is to attempt to clarify the notion of potential partiality in the bill so that the different moving parts of that are more clearly comprehensible to everybody looking at the law. I bring this as a clarifying amendment. Particularly, I bring this to clarify the applicability of waiver provisions, and I ask for your support.
Thank you. Any discussion on L015? Representative Wist.
Thank you, Mr. Chair. My question is, don't these requirements already exist in existing statute under the Uniform Arbitration Act?
Representative Weissman.
There are certain provisions concerning non-conflict of interest in 1322, I think it's 212, that do apply the intent of this bill, not even for all arbitrations, but for certain consumer and employment arbitrations as defined in the bill, is to add a little bit more transparency and a little bit more in the way of guardrails for folks subject to these arbitrations where there may be a little bit less parity in contract formation power.
Representative Wist.
Thank you, Mr. Chair. I ask for a no vote on this amendment. We're monkeying with the Uniform Arbitration Act. I think we're doing it in a fairly haphazard manner. This is a uniform act that's worked very, very well and given us predictability in this process for many, many years. I think we're doing this on an ad hoc basis. It's not wise. I certainly think it will result in more cases going to litigation and increase costs for litigants and consumers across the board. Ask for a no vote.
Representative Weissman.
Thank you. Members, you may wish to be a no on the bill, but I do think that you should be a yes on the amendment because this only seeks to clarify what is already in the bill, particularly concerning the right of parties to agree in writing post-dispute to waive all of the remedies set forth herein. I think clarity is to be sought for in what we do. I ask for your support on L15.
Seeing no further discussion, the question before us is the adoption of L015. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it. L015 is adopted. Representative Weissman to the bill.
Thank you, Mr. Chair. I move L16 to the bill.
Members, you have heard the motion And L016 is now properly displayed. Representative Weissman.
Thank you, members. L16 does three things. It clarifies the arbitration conflicts checklist in Section 707 of the legislation. It clarifies the applicability of reasonable privacy concerns and confidentiality in agreements that may be enforced as between the parties. And at the bottom, it clarifies that the same immunity that an arbitrator already enjoys under the UAA applies here too. It was never the intent to do otherwise. This is a clarifying amendment at the bottom brought in response to some comments made by the ADR section of the bar in committee. I ask for your support of L16.
Representative Wist.
Thank you, Mr. Chair. Well, I'm starting to get a little frustrated because these are significant amendments to this piece of legislation. I take great pride in the work that our Judiciary Committee does in terms of vetting these amendments. So my question is, why are we doing such extensive amending of this very, very important bill on the floor? I'm not sure what new things have arisen since our committee hearing last week, but I think it certainly would have been in our interest for the members of the Judiciary Committee to vet this. So I ask for a no vote.
Representative Weissman.
Thank you. And members, I guess the way that I would respond to that is I am attempting to clarify in these amendments issues that have been brought forward. Subsequent to committee, I have offered for weeks to all stakeholders to suggest page and line level changes to address concerns in the legislation. From a number of groups, I received no response to those inquiries, so I'm attempting to respond here to things that I have heard to add clarity to the bill and to address concerns that were brought to my attention.
Thank you. Representative Wist.
Thank you, Mr. Chair. I offer a motion to refer this bill back to the Judiciary Committee for consideration of these amendments.
Members, you have heard the motion. Madam Majority Leader Becker.
Thank you, Mr. Chair. I ask for a brief recess.
The body will stand in a brief recess. Sorry, one moment. Members, the Committee of the Whole will come back to order. The motion before us is to refer House Bill 1261 back to the Judiciary Committee. This is a voice vote. All those in favor, please say aye. Aye. Those opposed, no. No. The noes have it. The motion fails. Representative Weissman, back to the bill.
Thank you, Mr. Chair. Can I clarify? Are we to L16?
Pardon me. That is absolutely correct. The motion before us is Amendment L016.
Thank you, members. As a reminder, this clarifies the contents of the checklist. It clarifies the applicability of privacy concerns and confidentiality agreements, clarifies that arbitrator immunity continues to apply. I ask for your support of these clarifying amendments.
Seeing no further discussion, the question before us is the adoption of L016. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it. L016 is adopted. Representative Pabon.
Thank you, Mr. Chair, and members, I've really very much appreciated the discussion. I have a further amendment that recognizes that the duties and obligations associated with arbitration, arbiters, and those who practice in this area do have some overlap with our Judicial Code of Conduct as well as our Colorado Code of Professional Conduct. And so I move L014 and ask that it be displayed.
Members, you have heard the motion on L014 that has been properly moved and displayed. Representative Pabon to the amendment.
Thank you, Mr. Chair. And what we can do with this bill, and I appreciate Representative Weissman bringing this discussion to the chamber, is that we can recognize that there's actually been some pretty strong work by the judicial branch in ferreting out and recognizing conflicts of interest, what the code of conduct should be when essentially stepping into the role of a judicial decision. An arbiter does that when they step into an arbitration. And also recognizing the conflicts of interest that exist that myself and any other attorney who are in this building have to adhere to in any given analysis when we take on a new matter, whether it be a client or an arbitration or whatever it might be. And so this recognizes that this is a multi-pronged, multi-branch issue. And so we recognize that we want those rules to apply here and give a way to reconcile both the well-established rules of judicial conduct and code of professional conduct with the duties and requirements of House Bill 1261. So I would ask for a yes vote.
Representative Wist.
Thank you, Mr. Chair. Well, I'm going to surprise you. I think this is a thoughtful amendment, Representative Pabon, and I urge an aye vote on 014.
Seeing no further discussion, the question before us is the adoption of L014. All those in favor, please say aye. Aye. Those opposed, no. L014 is adopted. Mr. Minority Leader.
Thank you, Mr. Chair. I move L017 and ask that it be displayed.
Members, you have heard the motion on L017. It has been properly moved and displayed. Minority Leader Neville.
Thank you, Mr. Chair. Members, we've heard a lot of amendments trying to make this bill better, trying to make it palatable, trying to make the bill worthwhile. Well, this is the one amendment that would actually make this bill palatable. I urge a yes vote.
Representative Weissman.
Thank you, Mr. Chair. I had a tingling this morning that I was going to see a strike the enacting clause amendment on the floor today, and that's what we have in front of us. Members, this kills the bill, and I appreciate the sense of humor of the Minority Leader, but I ask for a no vote.
Seeing no further discussion on L017, all those in favor, please say aye. Aye. Those opposed, no. No. That amendment fails. Representative Weissman.
Thank you, Mr. Chair. I appreciate the support of the Assistant Minority Leader on Representative Pabon's amendment. I think it's an appropriate change. Members, just to clarify what this is and is not about. It is not about all forms of alternative dispute resolution. It is not about mediation. It is not about post-dispute arbitration. And remember that parties who agree in writing can waive out of the provisions of this bill entirely. One of the interesting things I found about this subject was a quote from a federal judge appointed by former President Ronald Reagan concerning arbitration, who said, "This is among the most profound shifts in our legal history." In this case, I agree with that Reagan-appointed federal judge. For that reason, I bring 1261 for the sake of a little bit more procedural protection for consumer and employment arbitrations, and I ask for your support on the bill.
Representative Sane. Representative Sane.
Thank you, Mr. Chair. I'd like to move L018 and ask that it be properly displayed.
Members, you have heard the motion on L018 that has been properly moved and displayed. Representative Sane.
Thank you, Mr. Chair. Members, I have heard that we want to add some kind of language. This bill, in fact, adds a whole new section to statute, a very, very, very long section of statute to which we just heard some very substantive amendments. Well, I agree with the intent of the bill, so I am offering this amendment to make sure that the General Assembly finds and declares it is policy of the state to ensure that private arbitration is fair and impartial. Ask for a yes vote.
Representative Weissman.
I appreciate the spirit of the amendment to make sure that arbitration is fair and impartial, and in fact that is the entire point of 1261, the detailed provisions of which have been roughly a year in the making. So rather than a statement of policy as contemplated by the amendment, I would urge the committee's support of the bill, and I would ask for a no vote on the amendment because let's do the details too.
The question before us is the adoption of L018. All those in favor, please say aye. Those opposed, no. L018 fails. We are back to the bill. Representative Weissman.
Renew my request for support.
Seeing no further discussion, Representative Wist.
Thank you, Mr. Chair. So let's talk about why this bill is not necessary. And as suggested by the amendment that was just before you, is Colorado law clear that arbitrations are fair and impartial? Absolutely. Is a new statute needed? Absolutely not. Well, let's talk about what rules already exist today. Most arbitrators are attorneys. They're already subject to the code of professional or the rules of professional conduct. Here are the rules under the rules of professional conduct that apply to arbitration. Rule 1.6, confidentiality of information. Rules 1.7 and Rule 1.8, conflicts of interest. Rules 1.12A, future engagements by arbitrators. Rule 2.4, lawyers serving as a third party neutral. Rule 3.3, candor to the tribunal, and Rule 3.5, impartiality and decorum of the tribunal. Completely duplicative and unneeded are the provisions of this bill which relate to the ethical rules for arbitrators. Number two, under both the Federal Arbitration Act and the Colorado Uniform Arbitration Act, the partiality of an arbitrator is grounds for vacating an arbitration award. That's under 9 U.S.C. Section 10A2 under the Federal Arbitration Act and Section 1322-223, 1A and B under the Colorado Uniform Arbitration Act. Number three, courts have the discretion to police an arbitrator's impartiality by vacating arbitration awards that are tainted by biased arbitrators, including in cases of pecuniary interest, familiar relationship, and the existence of an adversarial or sympathetic relationship. Members, for a lot of the reasons we discussed earlier today, this bill is a solution in search of a problem. Our arbitrations have worked well for years. Why are we monkeying with this? Well, it's important to me that the Bar Association is very opposed to this bill. The people that are involved in doing these arbitrations and vet these rules and look at making sure that these processes are fair and impartial is strongly opposed to this bill. I suggest that should give you pause before you support this legislation. I ask for a no vote on 1261.
Representative Carver.
Thank you, Mr. Chair. The Colorado Bar Association provided as extensive testimony against 1261 as they did the earlier bill. And if you want to know, although the testimony was even longer than these bullet points would convey, the list of their objections is a page and a half of bullet points. Not, we don't like the process, not that we think it will cause problems, but no, specific issues detailed out, bullet statement after bullet statement, on the disruption this will cause to arbitration, on internal conflicts that it will create in the statutory language itself. Bullet number 1, risk confidentiality of arbitration awards. Confidentiality agreements and arbitration clauses could prohibit disclosure or could be eliminated. So that's just the opening salvo, and it goes on from there. Specific issues, problems created by this bill, the way it is drafted, conflicts with the Federal Arbitration Act. The Colorado Bar Association section has no dog in the fight whether it is pro-business or pro-consumer. These are the folks that do arbitration, who believe in arbitration, who believe in a process that is fair and impartial and that has integrity. And they are saying this bill will be hugely disruptive. They also stated in testimony and renew their objection that they believe there are aspects of this bill which will cause arbitrators to cease pursuing their occupation. Aside from being an onerous administrative expense and invasion of privacy of those involved in previous arbitrations, they're talking about disclosures, no reason exists for requiring disclosures beyond what is already provided. So, members, we've had a long discussion. Suffice it to say, this is not a bill that is ready to go forward, particularly with the very complex and substantive amendments that we just voted on, that were not vetted, that we have not had an opportunity to discuss with stakeholders. Before we mess up our arbitration process, we owe them that work. And respectfully, I ask for a no vote on this bill.
Representative Weissman.
Thank you, Mr. Chair. And members, let's be clear, there is no conflict with the Federal Arbitration Act because there can be no conflict with the Federal Arbitration Act under the Supremacy Clause. State law now and state law under this bill must yield and will yield, and there is no ambiguity about that, and part of the amendments we just adopted was to be even more pellucidly clear about that reality than we're already trying to be. To some of the prior points raised, it is quite true that some arbiters are judges, and I think that's great, and all things equal, those are probably the better arbiters out there. And other arbiters are attorneys who haven't ever been judges, and they're probably better arbiters than average too. But members, the reality is that there are really no requirements to be an arbiter and to decide people's rights in Colorado. Anybody in this chamber could go hang out a shingle as an arbiter and start attracting clients tomorrow. And while some of the provisions alluded to by my colleague from Arapahoe County do apply to attorney arbiters, they don't apply to non-attorney arbiters, and that's really the entire point of the bill, and again, I appreciate Rep. Pabone's amendment to slightly tweak how the legislation addresses that. It's also been stated that arbitration is working fine. Well, I would submit that it's working fine for some parties who choose to submit to it, and I've tried to be clear. I don't dispute that. I think there are some cases where arbitration has been and will continue to work just fine. And if parties choose that equally, it's not the intent of this legislation to step in the middle of that contractual agreement. But I think clients of the Wells Fargo Bank who have had a fraud perpetrated against them and then subject to arbitration would say that maybe it's not working so well. Folks who have had near misses or hits with loved ones in nursing homes and have been subject or nearly subject to arbitration provisions would say it's not working so well for them. Folks who had their data breached in Equifax and were then almost subject to arbitration provisions might say that it's not working so well for them. And certain folks who have been forced into arbitration proceedings to resolve workplace sexual harassment disputes might say that it's not working so well for them either. And these groups do support this legislation for those and other concerns. The AARP, Colorado Common Cause, the Colorado Cross Disability Coalition, the Denver chapter of the Colorado Latino Forum, the Colorado Senior Lobby, Disability Law Colorado, the Interfaith Alliance, the Lutheran Advocacy Ministry, the NAACP, the National Council of Jewish Women, One Colorado, Vet Voices, the Vote Vets Foundation, and the Women's Lobby of Colorado, and that's only about half of the list. I ask for your support.
Seeing no further discussion, the question, Representative Sane.
Thank you, Mr. Chair. I appreciate the intent which this bill has brought forward. However, if you were to create a visual analog scale of this bill, I don't think you could do it. There are so many dots you'd have to connect, and they all intersect this way and that. I'm reading on, page 8. If somebody has even expressed an opinion as to capacity in the previous sentences, they may be disqualified. An opinion, if they were previously a government employee or if they were in some kind of previous matter. I mean, this is a Gordian knot for which no arbiter would continue their profession. You'd have to have a man from Mars come down and do this arbitration. So I would respectfully urge a no vote, even though I appreciate, again, the intent from which this bill is brought forward, but this is something that will completely hobble any kind of arbitration in the future here in Colorado.
Representative Wist.
Thank you, Mr. Chair. Members, thank you for your attention during this very important debate. This will be my last comment for the morning. It is still morning, by about 10 more minutes. Some comments for you about the position of this law with respect to the Federal Arbitration Act. If you look at, and I think the Bar Association has specific concerns about this, if you look at 1261 and 1262 together, if these bills pass and become law, we are enacting sweeping changes to the laws with respect to arbitration in this state. The U.S. Supreme Court has held on many occasions, that the Federal Arbitration Act has broad preemptive power. And in its 2011 Concepcion decision, the court said that the Federal Arbitration Act preempts state law rules that stand as an obstacle to the accomplishment of the Federal Arbitration Act's objectives. I suggest if you look at these broad sweeping changes that we're making in these two pieces of legislation, the Bar Association is concerned about how it fits within the framework of the Federal Arbitration Act, as do I. Again, I ask for a no vote on 1261.
Seeing no further discussion, the question before us is the adoption of 1260. Division has been called. Division has been called on House Bill 1261. Members, the question before us is the adoption of House Bill 1261. A division has been requested. All those in the chamber not entitled to vote, please be seated. All those in favor of House Bill 1261, please stand and remain standing in one place until a vote is counted. You may be seated. All those opposed, please stand and remain standing in one place until the count is taken. You may be seated. House Bill 1261 is passed. Madam Majority Leader.
Thank you, Mr. Chair. I move that we rise and report.
You have heard the motion. Seeing no objection, the committee will rise and report.
House will come to order. Mr. Randall, please read the report of the Committee of the Whole.
Madam Speaker, the committee will vigorously report as illustration the following touch bills being a agreement therefore makes the following recommendations thereon. House Bill 1065 is amended. House Bill 1109 is amended. House Bill 1249 is amended. House Bill 1211 is amended. House Bill 1234 is amended. House Bill 1243, House Bill 1250 is amended. House Bill 1261 is amended. House Bill 1275, House Bill 1282 passes under placed to count for third reading and final passage. Senate Bill 107 passes under reading order of vice, placed to count for third reading and final passage.
Representative Hansen. All right, that's been properly moved. There is an amendment at the desk. The Assistant Minority Leader Wist has an amendment. Mr. Randall, would you like to read the Representative Wist's amendment to the report of the Committee of the Whole?
Representative Wist moved to amend the report of the committee to hold to reverse the action taken by the committee in adopting House Bill 1261 to show that House Bill 1261 as amended lost.
Assistant Minority Leader Wist.
Thank you, Madam Speaker. I move the Wist amendment to the report of the Committee of the Whole.
All right, properly moved. Assistant Minority Leader Wist.
Thank you, Madam Speaker. Members, I'm going to quote to you from a communication from the Colorado Bar Association and ask that you pay close attention to what our colleagues in the Bar Association are saying about this bill. There has been no information provided that would show the current arbitration statute is ineffective in the requirement of disclosures by arbitrators and in the adjudication process. The Bar is willing to meet further with the stakeholders to discuss concerns and perhaps offer alternative means to satisfy the issues raised by the bill's sponsor in a way that is not so disruptive and in conflict with the arbitration statute in Colorado. I agree with the Bar Association. I ask for a yes vote on this amendment to the Committee of the Whole.
Further discussion? Representative Weissman.
Thank you, Madam Speaker. I'm not going to restate the debate that we had on second reading, but this bill is intended to work in conjunction with and not to replace the existing Uniform Arbitration Act, because this bill, by its own design, does not apply to all arbitrations. It applies to consumer and employment arbitrations. And why might that be necessary? Because as of last year, more than 60 million Americans were subject to arbitration clauses in their employment contracts. And some of them may have chosen that, and most didn't. 65%, two-thirds, of employees in large companies of 1,000 or more employees are subject to such provisions. And on the consumer side, here's just an example of where arbitration clauses may be found. Airbnb, car loans, Care.com for babysitting, subscribing to the Denver Post, getting a credit card from Discover, Equifax, doing your taxes with H&R Block, Metro PCS cell phones, Microsoft Office, Pokemon Go, Nintendo, Legos, child's toys. This is the breadth of the reach of arbitration clauses in our economy today, and this bill does not even propose to change that. It simply proposes that when arbitrations arise out of those clauses, that they be a little bit more fair. So I ask for a no vote on the cow.
Further discussion on the Representative Wist amendment? Seeing no further discussion on the amendment, Mr. Randall, please open the machine, and members, please proceed to vote on the Representative Wist amendment to the report of the Committee of the Whole. Please close the machine. With 26 yes votes, 34 no votes, 4 excused, and 1 vacant, the Representative Wist amendment to the report of the Committee of the Whole is lost. That takes us back to adopting the report of the Committee of the Whole. There are no other amendments at the desk. Mr. Randall, please open the machine, and members, please proceed to vote on the report of the Committee of the Whole. Please close the machine. With 36 yes votes, 24 no votes, 4 excused, and 1 vacant, the report of the Committee of the Whole is adopted. Announcements and introductions. Representative Singer.
Thank you, Madam Speaker. Once again, don't forget about the Children's Caucus on Monday. We'll see you there at 12 for lunch and some valuable discussions. Also, Public Health Care and Human Services Committee. We will not be meeting today, but on Tuesday, we will be having a short day. House Bill 1288 will not be heard. So House Bill 1288 will be laid over for a week so we can get conflict-free case management conflict-free. Look forward to seeing you then.
Further announcements and introductions. Representative Eskar.
Thank you, Madam Speaker. Members who live south of Denver, listen up. I was just checking the road conditions, and I just want to give you an announcement that I-25 is closed at Colorado Boulevard heading south due to a crash. No estimated time of reopening, so rethink your routes on your way home.
Oh, goodness. Representative Winkle.
Thank you, Madam Speaker. And Monday will be a great day here at the Capitol because the McDonald's will be here, and they will be giving free Egg McMuffins to anyone at the Capitol. Free Egg McMuffins, that is right. Outside the old Supreme Court chambers Monday morning.
Representative Sayers.
Thank you, Madam Speaker. I respectfully request to be excused 28 through 30 March. The paperwork has been filed and signed.
Thank you, Representative Sayers. You are excused. Further announcements or introductions? Seeing none. Madam Majority Leader Becker.
Thank you, Madam Chair. I move to lay over the balance of the calendar till Monday, March 26th.
Seeing no objection, the balance of the calendar will be laid over. Madam Majority Leader Becker.
Thank you, Madam Speaker. I move that we the House stand in recess till 1 o'clock today.
All right. Seeing no objection, the House will stand in recess. Thank you, members, for your work. Have a wonderful weekend.